non-availability of the assignment register is not due to any reason attributable to the petitioner's hearing and the petitioner's.
Therefore, once you admit, madam, you understand, right?
Yes, madam.
Then
The question here, which was failed to be taken into account by the learned single judges, madam, there was no subdivision of survey number 427. And
no, madam, the fact that the petitioners were assignees of land and were shown as pattedars has not been disputed by you.
They were not, it's not disputed, my lord, but we are saying that they are in certain land of 427.
What to do? Yes.
My lord, the counter which we have filed before the learned single judge, we do say, my lord, that they are shown as assignees, but in certain land of 427, not in the land.
Therefore, there is a direction to identify the land.
I'm only seeking.
If the land is identified,
yes,
then fine, otherwise pay compensation.
I'm seeking
or some alternate land.
Some modification of time, my lord, with regards to time. Some more time is granted, will come.
That you can grant 2 more months time.
Very well.
That's why you started like that, no? Started by saying 2 months, right? Mark the presence.
I'm representing on behalf of the division of respondents.
Heard on IA1 of 2023. You are appearing for respondents.
Yes, my lords.
Heard on IA1 of 23. For the reasons assigned in the application, duly supported by an affidavit, we find that sufficient cause for condonation of delay. Of how many days, madam?
136 days.
36 days in filing the appeal is made out. Accordingly, delay in filing the appeal is condoned. IA is allowed. This intra-court appeal has been filed against an order dated 10th of March 2023, passed by learned single judge, by which writ petition preferred by the respondents has been disposed of. Paragraph. The learned single judge. Paragraph. The respondents stroke petitioners have filed a petition seeking a
Petitioners
What, Mr.?
yes, treated as ineligible for not uploading ninth class bona fide.
Why don't you do it? 26/7/23 you have been declared ineligible. Now after when? Today is what?
Today is 21st or 6th.
You are waiting for 2 months to complete, right?
Lordship,
And
the
then what?
petitioners, father, they are from rural background, Lordship, they don't know. I can't come on, but she is delayed, Lordship, but one submission, Lordship, phase 2 of the PDS counseling has not yet commenced. They can consider, Lordship. It is the only not submission.
Why? But why you did not? These timelines are fixed for everyone. Why a special treatment to you?
Lordship, I'm not.
It's up to Mr. Rao. If he says he can do it, he can do it.
But
This court will have.
But one submission, Lordship.
Will you?
Daily from Andhra Pradesh, they will use the progress certificate from Telangana, published an inquiry from the criminal petition, they were debarred. After time directly it was considered
Lordship, one
they will consider.
this law is not about local, non-local, it's about the not submitting my, Lordship, they accept 10th class, Lordship, page 14 is Lordship for a
We will not accept. I mean, this is the
Lordship,
most we can do for you. Consider.
Lordship, one submission, Lordship, I will not take much shit over. Page 49, Lordships, the bona fide certificate for 9th.
No, Mr. If you want us to pass an order on merits, please explain. 26/7/2023, you were declared ineligible. Why have you come after nearly 2 months? Number one, delay. Explain the delay. Then secondly, what is the reason for non-furnishing? It is not for their fault that you did not furnish.
Lordship,
Why? I mean, we should this thing deviate from the general rule and grant you why?
Lordship, one submission, Lordship, page 49, Lordship, they accept the bona fide certificate. Lordship, they accept bona fide certificate for 10th class. The bona fide.
Why you did not furnish, Mr.
Lordship,
And
we have
what were you doing for 2 months?
Lordship, it's the same bona fide certificate, 9th and 10th, same. Page 49. They
You have
accept
been declared in. Is it your case that despite furnishing, you have been declared ineligible on 26/7?
Lordship, we have furnished all the documents and they have accepted for 10th class. The same bona fide certificate, they're not accepting for 9th class.
Not, Mr. Not acceptance and non-furnishing are two different things.
Lordship,
Please understand the distinction. Non-furnishing and non-acceptance are two different things. You are very conveniently using the
page 45, we have furnished, Lordship, for a minute. Their own certificate, page 45. It's admission certificate. It is not that we have not submitted. Page class.
find out, Mr. So this case is altogether different. We thought he has not furnished. Learned counsel for the petitioner submits. Heard on the question of admission, learned counsel for the petitioner submits that even though the petitioner had furnished a residence certificate, yet he bona fide certificate, yet he was declared ineligible on 26/7/2023. It is further submitted that the second round of counseling is scheduled to be held shortly. Let me see the counsel. You stand like. So when?
Lordship, date has not been given, Lordship. It is for
So what is the explanation when a query was put to learned counsel for the petitioner? Yes, right. When a query was put to learned counsel for the petitioner that even though the petitioner was declared ineligible, the petitioner filed the writ
options and petitioner is treated as ineligible for.
What is wrong with the rule?
Lordship, I'm not wrong, Lordship, but the
You
submission.
have challenged the rule, right?
Lordship, the submission, what I just want to make before your Lordship says, page 51 is a further notification issued by the registrar for entertaining a fresh registration, Lordship, in spite of the rule. Lordship, relaxing the condition where the GO number 125 says that, for a minute, Lordship, no fresh registrations can be permitted once it is done. Page 19, Lordship. Page 19. No fresh registrations are permitted after last date of online registration as notified by the university. Lordship, pursuant to this, Lordship,
No, where the rule you are challenging is at page 19A, right?
19A, Lordship, this rule. What I just, 19(1) was relaxed by the university, Lordship, page 51 for a minute. Fresh registrations were considered, Lordship, after last date, Lordship, fresh notification.
Mr. Please read the rule. What is it? You are challenging the validity of a rule without even reading it. What is the rule? If it debars a candidate if he has not exercised the web options in the first phase of counseling, he is debarred from participating in the further round of counseling. What, Mr.?
For that reason, Lordship.
How can, I mean, this is a disabling provision so far as candidate is concerned.
Lordship, here is
What ground it is arbitrary and discriminatory, what like that?
Lordship, for that reason, Lordship, Lordship, the DO says.
It must have been upheld some, Mr. Rao, sometime. Huh? No, challenging the virus of the provision. No, you find out. I mean, we are not inclined to, we are just asked you. Otherwise, we will write an order right away. We are not convinced. He has not made out any ground of challenging the provision. So what ground you are challenging?
For that reason, Lordship, for a minute, if you Lordship grants me a minute. Page 51 is a further notification was issued by the registrar, Lordship, first 4 lines, Lordship, in continuation of notifications dated so and so, so and so, the can hereby notifies online registrations for new for qualified who have not registered in response to the earlier notifications. Lordship, the government, the registrar has relaxed the condition, first condition of US members number 125 for fresh registration. Lordship, here is the case.
No, for that reason, the rule does not become invalid. For that reason, you can say that the notification should be quashed because it is contrary to the rule. That is understandable.
Lordship, but I can also be treated as fresh candidate for fresh registration. But I am restricted for fresh registration.
No, we will not permit anything which runs contrary to the rule, Mr.
Lordship.
If you are raising a contention that the notification dated 11/9/23 should be quashed because in contravention of the rule, understandable. That is not your case.
Lordship, what my submission is in this other way, when they can relax and they can give.
No. If they can permit others to commit theft, I should also be permitted. This is the relief court of law cannot grant. If Mr. Rao can do it, he can do it. We can't do it.
They always say that
this is like saying
registrations cannot be permitted.
Mr. There is no concept of negative equality in law. Please understand. If others are being this thing granted the benefit, you can very well challenge that this thing we understand. But that is not your case. That this notification dated 11/9/2016 should be quashed because it is in contravention of the rule. That is perfectly understandable. But you cannot say that. We don't know who are the others who are being permitted.
They are not restricting me, but Lordship, I did not opt for web options, Lordship. I have not.
So what is the prayer, Mr.?
Lordship, no, Lordship.
We don't think you have anything.
Lordship, interim prayer, Lordship, allow me to opt for web options. Allow me to opt for web options for next phase of counseling, Lordship.
No, but you have not argued anything about how the rule is arbitrary or this thing. You have challenging the rule just like and not arguing anything. We will dismiss it. We will dismiss the writ petition. There no ground has been urged to say that the rule making authority has power to make rules. Or is it your case that it does not have power?
For that, Lordship, page 16 may be taken, Lordship. They say that in the rule is amended for the URMS number 114, rule 4, subclass 4. Now here it says that candidates are permitted to exercise web options for each round of counseling separately. When they say that I can exercise the web options for each round of separately. Now they are putting a restriction clause, Lordship, further amending to it. Without amending to the first rule of GMS number 114.
Please again, how many times, second time we are telling you, your prayer in the petition is not that the notification dated 11/9/13/23 is contrary to rule. And therefore you are not seeking quashment of notification. We would have understood that.
I'm not,
Then,
not against the notification they issued for.
then we cannot permit, we cannot permit you to participate if you are disentitled under the rule.
Lord, GOMS number 114 says that I can participate, Lord, permitted to exercise each round separately.
No, whatever rule permits you do it, whatever. Mister, we are concerned, we are not concerned what you can do. You do whatever you can, but we are examining the validity of the rule. How is it bad? Please tell us.
But Lordship, without amending this rule, Lordship, GOMS number 5, they have put a restrictive clause under 125.
Nothing of it. See,
Different is different.
ask him to read. Para 7.
Para 7, please read para 7. From it is necessary, third line.
How do you draft the petitions, mister? And don't even read it. I mean, we are required to make you read in the court. What can be the
It should give us
You yourself are saying it is contrary to GOMS 125. Now what has to be decided now?
Lordship, I stated that it has issued
and seeking permission to appear to this thing permit in apply you. What is that?
Lordship, that notification is contrary to the GO. I admit, Lordship, that not.
No, you have not argued any ground, mister, for declaring the rule invalid. Yes.
Lordship, I'm not.
Anything else?
I'm not asking for rule to be there, that notification, because so many.
This is the challenge in
will be
the,
affected of that.
mister, this is the,
Notification.
please understand, I mean, you don't even read the prayer clause also of your petition.
But prayer, I challenge the rule, Lordship.
Then you are saying I am not challenging rule.
Notification, Lordship. I'm saying I'm not challenging the notification issued on 11/9. I'm challenging the rule.
Rule. That we will decide. Yes. Anything else? Because you have not argued why the rule is arbitrary and nothing. You have not said that rule making authority has no power to make rules. Nothing.
What rule is arbitrary?
Word on the question
Is
of
contrary to the GOMS number 114. Because that is what I just heard. GOMS number 114 says that I can exercise office for each round separate. And they are restricting from GOMS.
which provision?
Lordship, GOMS number 114, Lordships. Page 9.
Page.
17, Lordships. 16D. I'm sorry. 16D. Lord, 16D. Candidates are permitted to exercise.
One minute. Where are 16D?
16, Roman 4. Candidates are permitted to exercise web options for each round of counseling separately. So,
No, that refers to candidates who are eligible to participate. Doesn't mean.
I'm eligible.
All right, fine.
I'm not that I'm ineligible, Lordship.
That rule, small rule, formula operates a different situation. This rule, this operates different situation. There you are the candidates of the external web options. The candidates who are given admission, if you fail to take admission, they are debarred from further round of counseling. This is a different one.
No, and this rule, this 4 at 16D applies where they have exercised the web option but are not allotted seat.
Yeah.
Then again,
they can participate in. But there the candidate is allotted a seat.
all right.
Candidate is allotted a seat, I can go for a sliding. Or I may not, I can have a PhD.
Yes, mark the presence. You are NEET aspirant UG course, right? Undergraduate course. Yes, madam. Petitioner who is an aspirant Getting this order right. We will have to hear, instead of granting stay every day.
File on same day, my lord. Unfortunately, it's being listed.
Unfortunately,
In fact, it's all filed on one day.
done it, same order. Yes.
I'm obliged.
How many cases now?
No, it's not over.
Last, stop. Cash crop is over, right?
Waiting for us.
List, the same order, list along with WP number 25875 bar 2023 for an August hearing. Yes.
I'm obliged.
May I please? My grievance is, my lord, in spite of paying entire loan amount, my property was sold. My lord, I filed the writ petition. Writ petition, all through there was stay and disposed the writ petition to avail remedy available before the SURFACE Act, my lord. I filed an appeal along with the delay petition. The tribunal, my lord, on the ground, the tribunal has jurisdiction to entertain only up to 45 days. He has not considered the pendency of the writ petition and entire amount is paid, my lord. That's the only ground, my lord. He dismissed my.
But you are challenging the order dated 30th/6/23 passed by Debt Recovery Tribunal, correct? Appeal under section 18,
Correct.
Satyavati Tandon, consistent view. You people should now stop arguing for this court. See, we are repeatedly, Calcutta is a nice place, yes.
But
Who
the
told
parties
you?
of
This order is Satyavati Tandon, 3-judge bench of Honorable Supreme Court.
that I am
Yes.
every day I'm seeing, my lord, your
Seeing,
appeals
yes.
are not the order.
That's why we are saying, heard on the question
There
of
are another
admission.
two appeals are all.
Heard on the question of admission in this writ petition, the petitioner has
I'm obliged.
But there are two other appeals, but not numbered, get tomorrow.
please tomorrow.
Same, my lord.
You can give, yes.
My lord, I will.
All
See that it will.
Yeah.
May I please, my lords? I am for the petitioner, my lord. In this matter, the senior counsel Madan Mohan sir is appearing, my lord.
No senior counsel. You are senior counsel, right? What is this? Order 7 rule 14 application rejected. You are so senior counsel. We will this thing denotify if he appears in order 7 rule 14 and doesn't permit you to argue.
My
What
lord.
is this? Why it should not be taken on record, Mr. Tell us. What is the prejudice? Nothing. This all it should be. Otherwise, no. If this order is allowed to stand at the appellate stage, he will file an application under order 41 rule 27 and the appellate court will remand. What is this? You shouldn't even oppose. Yes. That we will never do, Mr. That we will never say that you conceded. Yes. In this, with consent of the parties, the matter is heard finally. In this writ petition under Article 227
Evidence, my lords. I am not.
Before evidence.
Yes, ma'am.
Before evidence he had filed. Admittedly, the petitioners had filed an application seeking production of documents before evidence, full stop, in order to afford an opportunity of hearing, opportunity of fair and just trial to the petitioners, the trial court ought to have allowed the application under Order 7, Rule 14 of the Code of Civil Procedure. Huh? Marking it, obviously, you will, there's no question of observing. This is only Order 7, Rule 14. That does not no, not necessary. That trial court will take care of.
Deeply obliged.
You know that, right? You will tell the trial court. Yes. Next. Yes.
Because I'm appearing in 10. 10 may not survive if your lordships take a decision in 11. If your lordship may kindly hear the 11, the item number 11 first.
Yeah.
I'm appealing for petition in item number 11, madam. We have already
Last time you had granted time to file counter somebody.
rejoined, madam.
Fine. All right. What is to be done, Mr.
May hear 11.
In 11, my lord, I'm requesting time, my lord, as senior counsel Elder Vichandra sir is appearing in this matter. Anytime next week, my lord. He is not available in the city today, my lord.
Item you appear for?
Item 11.
Which respondent, Mr.
Petitioner, sir.
Petitioner. Learned counsel for petitioner in item 11. Praise for short accommodation on the ground. What's your name? Right,
Mayur
name.
Mundra.
On the ground that the arguing counsel, Mr.
Elder Vichandra.
is not available. Senior counsel. One minute. So we will have it on 10th instead, 9th instead of 9th. 10th, 10th. 10th
Right.
October. Yes. Yes, next. Ah, yes.
Wait, please, Peter. The stay petition is for stay of recovery of default and
We want to hear you like on this question itself. What is prima facie? Yes,
just a short note on that.
yes.
Just one more. Lots.
Not stay. We are asking you to argue itself. We will decide it. Huh? If you are ready, or you can argue on Saturday if you want.
Yes,
Hmm?
actually, this time limit given expires today for payment.
Now, we are ready to hear today itself, but what we are, instead of arguing on stay, please argue finally.
I'm
If you are
obliged.
ready.
I'm obliged. My lord may kindly refer to the synopsis I gave at the time.
This one.
No, on 29th August, my lords were kind enough to
No,
admit
no.
this
So,
appeal.
see, Mr. The facts are that a complaint was filed on 12/7/2017 against you,
Yes, yes.
right?
In fact,
Alleging violation of the FEMA Act, right?
section 6,
And the section
6,
63B
subsection
was omitted
Clause
on
B.
15/10/1999.
yes,
And your submission is that this
impugned order
was show cause notice was issued
Without-
thereafter, and therefore it is without jurisdiction.
yes, following royal accommodation.
And this thing, this is the main submission that section 63B has been omitted with effect from 15/10/1999. Therefore, the proceeding which culminated into passing of the order dated 4th of January 23 is without jurisdiction, and you cannot be relegated to the alternative remedy of appeal.
Exactly.
Your case falls under one of the exceptions to Whirlpool.
And the learned single judge held that the first respondent had jurisdiction to pass the order. That is why
No, but we can, if you are aggrieved to that extent, we can keep that issue open. That notwithstanding notwithstanding that finding, it is open for you to raise in appeal this ground that the authority had no jurisdiction. If that you want, we can do that.
I'm challenging the assumption of jurisdiction itself.
Yes.
Continuing it.
Then necessarily we will have to give an opinion whether or not the authority had jurisdiction. Then you cannot say that the court has relegated you to an alternative remedy.
May I request my lord, then my lord may kindly take it day after tomorrow so that I will prepare. No.
That's why we told you.
Just to assist my lords, I just prepared to
Saturday.
just to assist my lord with a proper synopsis.
Saturday. We have a working Saturday,
Yes, my lord.
right?
No,
It
my
would
lord.
be an ideal day on Saturday.
Yes, my lord.
Let the appeal be listed for final disposal. Like, let the appeal be listed on 23rd September 2020.
Yes, my lord.
Yes, next.
Right, Lordship, I am representing on behalf of respondent, madam, coming for counter, madam. Lordship, kindly grant time counter. That's the process of motions has been initiated in order to
Ready, law clerk.
from tomorrow they are giving the web options.
Huh? 1 minute. You are seeking stay of a statutory
Yes,
provision. What?
Let them file the counter. At their own time, but meanwhile I deny my constitutional right.
Constitutional right?
Yes,
What is the constitutional right?
equal opportunity in public employment.
Huh? You are claiming promotion, right?
Yes,
To the post of headmaster.
it must have grade 2, Mr. Yes.
And you have challenged this thing,
Proceeding.
GOMS dated 23rd January 23.
Yes.
What is it?
In
What
GO
ground?
number 3, that's the petitioners are working.
By this GOMS statutory rules are framed, right? Where is Mr. Reddy? Rahul Reddy. Law clerk. Inform. Yes. Yes.
The petitioners are working.
The rules have been framed, right? By this GOMS 23rd January 23.
GOMS number 3, Millard.
There is an amendment to the rules.
Yes, Millard.
You are challenging that amendment. 1 minute. Let us understand, because you are not arguing, right? So you are challenging the amendment to the rules, and you want, by way of interim relief, stay of amendment. Why? When, what circumstances a provision, statutory provision is stayed by the court? Any idea?
Millard. For instance, a person appoints under TSC 2001 in one district, Millard. He was promoted in 2003 as a school assistant.
For grant stay.
In the same anomaly, the another person appoints in another district in HGT, they got promotion in 2005. Now these two persons are inserted into the zonal systems. Then B is becomes a senior, A becomes a junior. That's why this zonal system, the multi-zonal system is denying the right of the petitioners, which is obstructing them to not to get the promotions as the school assistant grade 2, as the atmosphere grade 2 members. That's as per the GOMS number 10. That's as per GOMS number 10 belongs. Jilla versus school teachers appointment and promotions, what of vacancy, whatever it is, should be taken a district, a revenue district as a unit. By the amending the GOMS number 10, now the proceedings 565.
You have got it listed on a mention memo. We don't. That's it. Anything else?
That's it. Petitioner number 1 is the serial number 69 in the district promotion list belongs. After amending the GOMS number 10, after implementation of the GOMS number 3.
No, Mr. What is, we are asking you why the amendment into the rule should be stayed. You are saying is 65, let it be 68 also. How does it matter? We are asking, your interim prayer is to stay the, this thing, stay the impugned rule.
The apex court clearly said in the judgment of B. Srilata versus state of Telangana.
So moment it is challenged, it should be stayed, right? The apex court said. Where is, which paragraph? What is the citation?
Para number.
No, what is the citation first?
In the same manner.
No, citation you don't get it. What is citation means? Where it is reported?
Indian court.
Where it is not reported judgment? Citation. Unreported judgment of Supreme Court you are relying. Now what does it say? There, this is Mr. Incomplete. It is incomplete. Tell him. Oh, please tell him.
This judgment is incomplete. There is no head nor tail, nothing. You have picked up some random paper, observations.
That means you have not even read it, right? It begins on the other end, learned additional advocate general. Whether a judgment begins like this? This is Mr. All. If we write in your praise in the order that this is what you are doing, incomplete, unreported judgment you are citing to mislead the court, what will happen?
I will file it before the.
Nothing. This is thoroughly misconceived prayer. Yes. In this petition, the petitioner has assailed the validity of GOMS number
Yes. So, madam, I got the petitioner pursuant to the notification issued by the respondent.
All right, so inadvertently you have filled in the wrong form. And when is the examination going to be held? 30th. Let him appear 30th September. For the post of civil judges.
Yes.
Learned counsel for the petitioner submits that the petitioner has 3 years of practice.
And standing counsel for the respondent.
Learned standing counsel, however, prays for adjournment to enable him to seek instructions and to file counter. In the meanwhile, it is directed that the petitioner shall be permitted to appear in the examination held for recruitment on the post of civil judges on 30th September 2023. However, his result shall not be declared without leave of the court.
Obliged.
Accordingly, IA 1/23 is allowed.
I like counter in the
Madam, present matters coming up for consideration of interim order, Your Lordship.
file. Is on the
Right.
Regularization.
There you write one minute. In the previous case, you write no case for grant of stay is made of statutory provision you have written. Even otherwise, it is well settled that without holding the statutory provision constitutionally valid, the court cannot issue a direction not to implement the statutory provision. Therefore, the relief sought, therefore the interim relief sought for by the petitioner can also not be granted. For this reason also cannot be granted. There you have written earlier one sentence now. See so and so, Dhanraj versus Vikram Singh and others, 23 SCC. Yes.
Find the counter in this matter.
Madam, my lord, coming up for consideration for interim orders.
Yes.
There is a challenge to the EO.
Saturday. You have gone through the counter, right?
Yes, madam.
We'll hear on 23rd. The respondents have marked their presence. Respondents have filed the counter list on 23rd September 23. Yes.
That.
This lordship, seems lordship, the official respondent filed counter in this today. I have filed today itself. Indeed, along with vacate state petition has been filed by me.
You have filed counters.
Yes, sir.
Vacate petition.
Vacate petition has
What
been
do you
filed.
want?
Official respondent filed counter in this lordship today. Lordship, I received papers today itself. Just fine for.
You, so they filed. So you are ready.
Just now received lordship.
Then say so, Mr. What do you want? We are second time asking.
That's what request time lordship for.
Learned counsel for the appellant prays for adjournment in order to enable him to go through the counter filed on behalf of respondents. List.
Meanwhile, my creed may be allowed, may not, because
We will see what is. Yes. List after 1 week. Yes.
Lord, I am petitioner's counsel at number 20, my lord.
Yesterday you have adopted the submissions, right?
Yes, madam. These matters were
Nothing he has to argue. 5 and 8.
5 and 6.
6 has to argue. Yes. Who is the counsel for 5 and 6?
The senior counsel will be appearing in virtual.
No, 5 and 6, mister. There was some counsel. Yesterday you have adopted the submissions of
Yes,
made
sir.
by them. Why again you are standing up? It's his fixed for his submissions. Where is he? Show his name 5 and 6.
May I make my submission, my lord? With the leave.
You are appearing for 5 and 6?
Yes, correct. For the council on record for response 5 and 6, my lord.
Yes. All right.
My lord, the respondents 5 and 6 are the beneficiaries or the purchasers of the property, my lord, from the society which is being represented by respondent number 7 and 8. The precise contention of the writ petitioner in the shape of PIL is seeking a mandamus to declare the action of official response 1 to 4 in granting permission to respondents 5 and 6 to make a complex construction over the subject property, which according to writ petitioners, it is a park earmarked in the layout approved way back in the year 1984-85.
It is earmarked as a park.
According to writ petitioner, first it was earmarked as park. Therefore, the allegation of writ petitioner is the respondent number 7 and 8 was appearing as the chairman and secretary of the society called the Indian Airlines Employees Housing Society. Unfortunately, the society is not made as a party in this writ petition, but then the society's representatives were made as parties.
Madam, you will not give.
Beg pardon,
No. Yes. Go ahead.
Yes.
So what are your Mr. We will appreciate if you can formulate your submissions and then perhaps elaborate.
Yes.
So what is your first submission?
The first submission is the averments made in the writ petition, can it be a qualified PIL based on the averments?
Averments made in the petition?
Can it be taken as the qualification to entertain application as PIL?
Cannot be taken. In view of averments made in the petition. Petition cannot be entertained as public interest.
Yes.
Yes. So that.
Apart from the writ petition, there were some other writ petitions which were disposed of by this honorable court on different occasions where similar relief was sought either as withdrawn or as dismissed. There are 2 judgments rendered by this court, which is filed along with my compilation.
Earlier writ petitions were dismissed.
Yes, Pilot. Either one is as withdrawn, another was dismissed.
Seeking. Yes. Next.
The third is the very writ petitioner who claims property in the layout is also abiding by the revised layout.
Who claims property in the layout?
In the revised layout, there are 2 layouts. Initially, the layout was according
to what is the submission that the same writ petitioners claims property in revised layout also?
Yes, which is related by the response 5 and 6.
No, so revised layout means it doesn't claim the land on which you are constructing or have constructed.
It's been constructed 2 decades back, not now.
So is he constructing the same? Is he claiming same land on which you have raised construction?
No, my lord.
Then
he is allotee of one of the plots in the layout approved.
Revised layout. Revised layout.
Personally, there is no dispute among the properties of petitioner and this response 5 and 6. They are distinct and different properties.
Allottees of plot in revised layout. So therefore, he cannot say that it is forced or something.
He is stopped from questioning the layout.
Stop from questioning the layout. Yes.
Yes.
What else?
Well, it per se to the statements made by the official respondents, it is apparent that a number of constructions which are made on this layout is in accordance to revised layout only, not only the subject property. Therefore, my lord, the revised layout is in principle ratified and accepted by all the parties, including petitioner and the authorities. My lords, when the revised layout stands unquestionable, the property which is acquired by the response 5 and 6 under registered sale deed way back in 1996 and constructed the commercial complex in accordance to sanction given by GHMC would stand appreciable, cannot be questioned. That would be my precise submission. I would elaborate on these aspects.
Yeah, what revised layout has been ratified, and what is the next last submission which you made?
When the constructions have come up in accordance to revised layout all over the plots, including the subject property, the inference is drawn. In principle, it is being accepted by everybody, and at this belated juncture, there can't be any raise by this petition, much less in the shape of PL, to say that there is no such revised layout. And only the provisional, the first layout has to be accepted, in which the subject property is earmarked as park. But that would be a no more better place.
Yes.
No, Millet. May I take my notes to the...
Yes, please.
In the present writ petition, which is item number 19, writ petition number 12538 of 99, Millet, for the sake of convenience, a compilation be placed by the advocate on record. May I request my notes to peruse from the compilation submitted by response 5 and 6, Millet, which is being circulated to everybody on record.
Yes.
It's a compilation booklet, Millet.
Yes. It begins with some death certificate.
No, Millet, the compilation starts with a memo, which is dated 11/9/2023, Millet. I'm sorry, Millet.
All right. No. Yes. Memo. 19/9/2023, right?
11/9/23, Millet. It was given with SR number 89039 of 2023, Millet.
19th September, right? It is dated 19th September.
No, Millet, it is 11 September 2023, Millet.
11 September. Madam, so this is something else.
Millet, this compilation is a booklet, Millet, consisting of about 300 pages.
Oh, yes. Yes, yellow and green thing, right?
Yes, Millet. Yes.
Yes.
I'm deeply obliged for.
Yes.
Yes. I'm deeply obliged.
Yes, please.
Millet, in this first writ petition, the counter affidavit of respondent number 2.
Counter affidavit
of respondent 2 would come at page number 13, Millet.
Yes.
Respondent 2 is the housing board, who is the crucial person to articulate between the beneficiaries and the Huda and the government. The contention of this housing board in one line at paragraph number 6, which would come at page 14. May take me to paragraph 5 also to have the clarity, Millet. 5 and 6 at page 14.
Yes.
Huda says, housing board says, it is submitted that the counter affidavit was filed on behalf of this respondent in the connected WP number 25738 of 97. I crave leave of this Honorable Court to read the contents of counter affidavit in WP number 25738 of 97 as part and parcel of this counter affidavit to avoid repetition. I will go to the other amendments, but then the crucial would be paragraph number 6. What it says, as regards the allegations made in para number 5 of the affidavit, it may be true that the MIG 64 could have been allotted to the petitioner. Let the petitioner contends in the writ petition that he is owner of this plot, house number MIG B64, which is allotted to him by the second respondent. That is the contention of writ petitioner, and it is being passed on by the second respondent to the writ petitioner. But Housing Board says in the next line, however, as per the records, the Housing Board did not execute the sale deed on 22/6/1996 in favor of the petitioner. The fact remains, Huda is only an articulative person with that of the society, which is not made as party in this writ petition, which is being represented by respondents 7 and 8 as chairman and secretary. The government made the allocated land for the society, which would be mediated by this APHP Housing Board under the approvals made by Huda as layout. But contention of writ petition, he got the property, his property, from the second respondent, which is not correct. Therefore, Huda is not the vendor. Vendor is the society, which is represented by respondents 7 and 8. Well, the 7 and 8 are executants of the documents for a petitioner as well as for this respondent 5 and 6. There is no difference between the executants of the sale deeds to the petitioner as well as this respondent 5 and 6. It's a common vendor. In the counter affidavit of
we told them that we will not go into the question of validity of the sale deed. We have told them SP Anand's case prohibits us from doing so. And so they were trying to, we will not go into, you need not labor on this aspect because we will not go into the question of validity of the sale deed. We have made it clear to counsel for petitioners also. Right, SP Anand. So now the only thing is whether in contravention of its use indicated an area earmarked for park has been, this thing, you have utilized it for the purpose of constructing a commercial complex.
Yes, my lord.
That's the only.
Yes, but the revised layout which is being relied even for the petitioner is of 1987, my lord. And the layout which is relying by the petitioner, the writ petition is of 1984, which is a tentative layout or the layout meant for approval.
When was the first layout? Initial layout?
1984, my lord.
And revised layout?
Revised layout of 1987, my lord. Yes. 1987.
Yes.
And my sale deeds of 1996, my lord. In fact, the sale deeds of every member of society is running from 1995, 96, 97, 98 onwards. Therefore, my lord, all these executions or the sale deeds were made in consequent revised layout, following the revised layout only.
Yes.
But the allegation of writ petitioner is there is some collusion among Housing Board or Huda or GHMC, and they helped these respondent numbers 5 and 6 in getting the permission for which the respondent 7 and 8 are unauthorized to mediate. The fact remains 7 and 8 are the persons who will transfer the property to every member, including petition, this respondent 5 and 6. And GHMC had accorded permission in accordance with its own bylaws. However, there might be a rider that in the event of any suppression of facts or misrepresentation that could be recalled, which I am not denying.
What?
Corporation has every right to recall its sanctions or permissions granted to individuals whenever it notices the suppression or misrepresentation of facts, my lord, before it.
Of course.
But here, where is the scope for this respondent number 5 and 6? Or the persons who are representing society like 7 and 8 to misrepresent the facts when there is layout in existence from 1987 itself.
You please tell us that in the layout, this area was marked for construction of shops and it has been put to use in accordance with the layout. That's it.
Yes, Millet. Millet, in the
Because MP, AP Housing Board and everybody else is saying that there is a tempering and it was earmarked for the purposes of park. Right? So please tell us that you have put the land to its use as per its use earmarked use in the development plan or the layout.
That this point was raised on the earlier occasion also. Therefore, this honorable court has appointed an inquiry officer in this regard, my lord.
Which writ petition? You said one petition was filed and it was dismissed and another one was withdrawn. Which
in the present writ petition, which is remitted now.
No, you told us that two earlier writ petitions were filed. One was dismissed, claiming same relief, and another one was withdrawn.
Yes, ma'am. That is at page number 141, my lord.
141.
Yes, ma'am.
Of your paper book, right?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
This is WP number
17494 of 1997. This is the application writ petition filed by one Mr. Muralidhar Rao, who is a colleague of the present writ petitioner also, and that was filed against 5 respondents. The relief sought in this writ petition is from 4th line of this prayer, my lord. Writ of mandamus declared that the permit number 50/49 of 96 granted in favor of 5th respondent Raghuram Reddy by the 1st respondent Municipal Corporation of Hyderabad in file number 10/TP7/CCP/96 in respect of park area in the same subject property. Park area in survey number 194/11, Faiga Lands, Begumpet, Secunderabad as illegal and set aside the same and direct the respondent to demolish all the illegal structures raised in the park area by Raghuram Reddy and Messrs. Integraph, and also direct the MCH of Hyderabad, Huda and the AP Housing Board to develop the park for the use of residents of Indian Airlines Employees Colony, Faiga Lands. But for the same subject properties for the writ filed. And unfortunately, the fact remains it is the present writ petitioner who is articulating in getting filed different writ petitions. That is being demonstrated from the order of this. The order would start in the bottom of this. What happened when neither the petitioner was present before the court, nor any such existing person was there, though it was taken as PIL again, PAL. That oral order is, it is a case where the existence of the petitioner itself has become doubtful. Obviously.
What happened to this petition?
Last 4 lines, of the same page, dismissed. That was dismissed,
Oral order, existence, all right.
It is the case where the existence of the petitioner itself has become doubtful. Obviously, somebody appears to have utilized the name of the petitioner for filing the writ petition in question. In the counter affidavit filed by the contesting respondents, it is stated in categorical terms that there is no person by name Muralidhar Rao, son of Dayakar, in the Indian Airlines Colony, Begumpet. It is further stated that there is no such house number 1-8-850 in the Indian Airlines Colony, Begumpet. Obviously, the petitioner appears to be a fictitious one. The law counsel for the petitioner was instructed to see that the petitioner is personally present in the court. The law counsel for the petitioner, consequent upon such direction, issued notice to the petitioner under registered post acknowledgement due, but the postal covers are returned with an endorsement that there is no such person and there is no such address as house number 1-8-850. The postal covers sent by the court under registered post acknowledgement due are also returned with the same endorsement that there is such house number and such person. In the circumstances, the conclusion is inescapable that some unsocial person used the name.
Mr. Senior Reddy, you will agree there is no adjudication on merits, right?
Absolutely.
Therefore, therefore, if you are trying to raise the contention of res judicata, it will not apply. Yes.
No, I'm not doing that. It's only to demonstrate the conduct of the petitioner and his sailors.
But the petitioner, whether it has been found that the petitioner filed the petition in name of Mr. Muralidhar Rao.
My lord, my contention is this is the petitioner present. Writ petitioner is the one who is steering to get filed this type of writ petitions only against this response 5 and 6, not against
In
others.
this case, identity of the petitioner who had filed the public interest litigation was not established. Therefore, petition was dismissed, right?
True. No, without an education, I admit, my lord, for that.
So, and next case, what is the other one petition you said?
Page 152, my legs.
152. Page 1. Yes.
Now that writ petition number 2965 of 1998.
Yes.
The relevant would be from page 154 as to what is the relief sought by the writ petitioner therein.
Yes.
Writ of mandamus declare in the action of the respondents herein in allowing the respondents 5 to 7 herein to construct commercial complex on the site situated in survey number 184 by 11 Begumpet, which is earmarked for park, public park, by issuing proceedings wide file number so and so 3/1/1997. This is permission granted by the corporation. On the file of second respondent herein as highly illegal, arbitrary, violative of Article 14 the Constitution of India, with a consequential direction to the respondents herein to demolish all illegal structures raised in the above said survey number, with a further direction to the respondent numbers 2 and 3 herein to develop park in the sites already earmarked and also directed for prosecution of all the persons concerned and responsible for the illegal construction. The order would be at page 155. Of course, it is also
withdrawn.
Adjudication. It is also not complete adjudication, my lord.
All right, yes.
The learned counsel for the petition.
Mr. But one of the, Mr. Senior Counsel, you will appreciate one of the tasks before you is to meet the reasonings given by a division bench of this court on an earlier occasion. Though technically the order is not in existence, it has been set aside by Honorable Supreme Court on that because parties agree for a fresh hearing, but nonetheless, you will have to meet the reasonings recorded by the earlier division bench.
Yes.
So these two petitions, one was this thing, one was dismissed, the other one was withdrawn, seeking the same relief. This is your submission. And the petitioner is getting these petitions filed.
Yes, time and again.
Oh.
My lord is aware that once PIL is taken up on record, the petitioner would be only the informant to the honorable.
Yes.
He cannot
he loses the locus. That's what we want. I mean, we want your submission to be heard by all counsels who are filing public interest litigations. They pursue it as if it's their own this thing.
Personal interest.
Personal interest and fight it out like this thing, court slip and everything. They forget that their role is over once the cause is brought to the notice of this court. Yes.
In fact, by virtue of making application before my lords by way of PIL, they would be status getting only informant but not the prosecutor for thereon. His own informant to the court, and it's for the court to make it. So here, in the most of the times, my lord, petitioner personal interest is being shielded and had come up in the shape of PILs.
Yes.
In the present case also, my lord, unfortunately, the granting authorities would have up the layouts. Here, Huda has not appeared in this writ petition and did not file counter. It's deliberately, I say. Huda did not file. Is the right person to speak whether the layout relied by the writ petition is to be considered or the revised layout has to be considered. That point to be answered properly by Huda, who is the competent authority. But unfortunately for the response 5 and 6, they kept silence. However, a counter is being filed in the other writ petition, Milad. That is the writ petition number 25738, which is item number 20. In the item number 20, the Huda has filed counter, and that counter would be at page number 247, my lords. Page 247 is the counter in the other writ petition filed by Huda, who is the authority to grant layouts or revise the layouts.
Yes.
Well, at paragraph number 3 at page 227, it is submitted that the Hyderabad Urban Development Authority granted layout permission for Indian Airlines Employees Housing Society situated in survey number 194 by 11 of Begumpet, wide LP number 2/85 by PD-1 Huda on kept blank, that is 1984. That's the reason why we are saying 84. While granting layout, the authority had shown the open spaces in 6 blocks. So this is the first tentative layout which was granted by Huda, which is relied by the writ petitioner. And there are 6 blocks earmarked for common other usages, different usages. What are they? They have been said continuously. Subsequently, in the report made by some of the employees that there are certain encroachments into the land of the office of the authority, inspected the site and found certain encroachments in open land. The authority immediately addressed a letter in July 1997 to the Municipal Corporation of Hyderabad mentioning about the encroachments and call for to furnish remarks on the said encroachment in the layout to take further action. Accordingly, the inspection report, the following are the encroachments made onto this open land. Like there are 6 blocks open in the first layout. On that 6 blocks, these are the encroachments according to the Huda. That is pocket 1, first block, which is subject matter of the present writ petition melody. This pocket 1, which is being defined in the counter, is the present subject matter. What it says, the construction of commercial building is completed with the framework for cellar floor and pillars raised for ground floor. The site in charge of the said commercial complex has informed that the permission was granted by MCH. So the construction which is made by 5 and 6 of the subject property, according to Huda, it is encroachment. Well, this is the counter which is filed in the year 1997. But by then I have taken the permission from DHMC, which they are accepting, but then that permission will be subject to recall, which is the second part. The second pocket is 2 MIG quarters are existing in the part of open land reserved for park and community hall in the approved layout, and also there is a shelter and electric transformer. But all the 6 blocks which were meant for common areas being encroached according to the Huda. It has so happened, Millard, this layout is being revived. That is
where are you reading? You first read at page 248, right?
Yes,
Authority has not received any information and the competent authority to demolish illegal is municipal corporation. Thereafter, where have you read?
Millard, in the top of this 248, pocket 1.
248.
248, 248.
Pocket 1. Pocket 1. Yes.
Yes, pocket 1.
Yes, yes.
This is with regard to the present subject matter, subject property, which is over which the respondents 5 and 6 made construction. What Huda says, Millard, the construction of commercial building is completed with the framework for cellar floor and pillars raised for ground floor. The site in charge of the said commercial complex has informed that the permission was granted by MCH. Now, this is one property. There are 6 properties similarly in the approved layout of 1984. Those 6 are number 2 to 6 pockets, which are mentioned below. Fortunately or unfortunately, this writ petitioner who wanted to make this as per the welfare of public didn't question these 2 to 6 pockets, the encroachments which were made. I'm not taking advantage of that non-questioning, but then to demonstrate the conduct of the writ petitioner, had this been the interest of public, all these encroachments as leveled at pocket number 2 to 6 would have been raised. At pocket number 2, 2 MIG quarters are existing in the part of open land reserved for park and community hall in the approved layout, and also there is a shelter and electric transformer. That is pocket number 2, which is meant open place. And pocket number 3, 2 old residential houses are existing in the open land reserved for park in the approved layout. Pocket number 4, there is 1 workshop of Messrs. Mohan Electrical Works covered in the part of open land and part of the road in the approved layout. Now, these things have so happened. By the time of counter filed by Huda, these are in existence for the reason it is being revived. Layout has been revived in 1987 itself. Therefore, there is variation between the layout which is being relied by the writ petitioner of 1984 and the layout which is to be accepted of 1987. Now we'll see where from this 1987 layout has been raised. Like to say that there is a layout of 1987 to eliminate the doubt which is being created, as to which one is the prevailing either of 1984 or 1987. Now, this court has ordered for an inquiry in the earlier process. That report is still part of the court record now. Now, that report, which is where the additional chief judge of Secunderabad is appointed as the inquiry officer and directed to furnish the report on this discrepancy, whether the park is subsisting or the layout primarily granted is subsisting or the subsequent layout of 87 would be valid. But on this minute, the report has been, after conducting detailed inquiry, a trial has been conducted by additional chief judge and furnished the report, which would be at page 157 of this compilation. It's at page 157 is the report. Well, it starts like this, the inquiry report.
Yes.
The Honorable High Court of AP in WP number 12538 of 99 and 25738 of 1997, the present item numbers 19 and 20. We pleased to pass an order dated 1/8/2000 directing this court for conducting an inquiry on the point as to whether the site in dispute was earmarked for park in the layout. That was the assignment given to the additional chief judge civil court Secunderabad to ascertain by this honorable court. The parties were directed to appear and they have filed their respective statements and evidences were reduced when documents were exhibited. Having considered all the pleadings set out by all the parties, that the court has made an observation which would start from page number 184, my lord. The point which is considered by the additional chief judge as part of inquiry would start from page 184.
Yes.
At paragraph number 33 at 184. My lords, but there is some visibility is less on this numbering. I'm sorry for that. Paragraph 33. The point to be decided as per the directions of the Honorable High Court of AP is as to whether the site in dispute was earmarked for park in the layout in question. Paragraph 34 starts like this, my lord. Practically, there is no dispute with regard to fact that the site in dispute was earmarked for park in the original proposed layout. It was originally proposed layout, my lord. Exhibit B5 is the sketch pertaining to proposed layout plan of the year 1984. Which the report is still depending on. This is the original plan. In this plan, the dispute site is identified as ABCD and it is noted as park. As already noted, it is everybody's case that in the beginning, in the year 1984 proposed layout plan, the disputed site was earmarked as park. It would not be with if I say the site in dispute was earmarked for park in the year 1984 in the layout in question. In the light of the subsequent developments and the contents of the rival parties, I will discuss the contentions and controversies in the paragraph to follow. A lengthy investigation was made. 4 witnesses were examined. The writ petition was examined as PW1 and RW1 to RW3 were examined. The index of witnesses examined also there at the end of this, which would be at page number 202. This would demonstrate as to how many witnesses were examined while giving the opportunity to the petitioner also, writ petitioner also. Page 202 would reveal the witnesses who were examined and the exhibit documents which were exhibited. It has gone as if like a civil suit trial. The PW1 who is appearing at page 202 is the second petitioner in the second writ petition. And the RW1 to RW3 are the officers of housing board as well as the secretary of the society and one of the respondents out of 5 and 6. Here the exhibit B1 on the same page is the revised layout which is being depended by this 5 and 6. Now that revised layout is in question whether it is genuine or tampered. Fact remains exhibit B5 which is slated here on this page 202 is not in dispute. Well, that was the first layout proposed. But it's being followed by a consequential revised layout at the exhibit B1. that this exhibit B1 is challenged or being alleged by the writ petitioner as it is done by impersonation or making various allegations against that it is being forged, tampered, etc., etc. And number of disqualifications have been raised onto this exhibit B1. That this exhibit B1 is supposed to be in the custody of either the respondent number 3 Huda or respondent number 2. And of course, a copy will be marked to GHMC also respondent number 4. The observations made by this inquiry the officer is at page number conclusion at page number 36.
Where is this order dated 1/8/2000? 1/8. Must be there. Yes.
Yes. It's page number 201. Yes, page. I'm sorry, it starts at 157 minute. 157, 18th August 2001.
No, this is the report, right?
Yes, Milad. The conclusion of this report.
What has been found in this report? That it is not tempered.
Yes, my lord. May I take my loss to the page number 201? That is the conclusion of the report. Page 201, my lords. One paragraph.
Yes.
That paragraph 56 would be at page 201.
Yes.
Consequent upon the discussion, from paragraph number 34 onwards, it is being discussed. But the flavor of all these paragraphs from 34 to 55 is precise in last paragraph 56. What it says, consequent upon the above discussion, I as the inquiry officer hold that there is absolutely no material on record to show that the site in dispute was still retained as park in the layout in question. After the revision of layout under exhibit B47 dated 10/4/1987. Of course, prior thereto, it was shown as park in the original proposed layout exhibit B5. Like now the validity of exhibit B5.
Yes.
The validity of this exhibit B5 would be no more relevance in view of exhibit B1 and B47. That is the revised layout plan which was issued on 10/4/1987. Now all the constructions made in this layout for this entire 12 acres which is obtained by the society is in accordance to 10/4/1987 layout only, permission approval only. Otherwise, we'll add as submitted counter by Huda in the other writ petition, there wouldn't have been such an encroachment. They are not encroachments, they all are purchasers. Two aspects to be asserted by now. If truly they were the encroachments, and the writ petitioner is so socially responsible that he wanted to see that no encroachments or violations from the public areas to be made for private utilities. If such is the case, all the 6 slots, with all the 6 blocks which were enumerated under the previous layout of 1984, they all should be utilized for these purposes, for the relevant purposes. Why the writ petition is so serious only against respondent number 5 and 6 of subject matter, which is pocket number 1? Had he been fair to the entire process, he should have raised this dispute even with regard to pocket numbers 2 to 6 as referred by the Huda in this counter affidavit. Therefore, this choosing process by the petitioner would demonstrate that it is his personal interest, not as a PIL. Had he been pursuing this in the interest of public, then the process should have gone for all the 6 pockets which is being divested for other purposes, then that of meant in the approved layout of 1984. As a matter of fact, my lord, the so-called first layout of 1984 is no more in emergence. It is there in 1987 merge. 87 rules prevailing.
How many shops have you constructed? How many shops have you constructed?
My lord, it is a complex concept, ground plus 3 floors, my lord.
So how many shops you got?
It is whole 3 Indias in accordance to permission given by JHMC, shops are constructed, my lord. It is a big shop mall,
It's a shopping mall, right?
Shops, my lord, and it has got offices like banks, etc. also established in that as by tenants. And not only altogether 600 square yards, it is different shops and offices because it is in different levels, ground plus 3 floors. But those structures were in accordance to GFM's approvals. But in case if you have deviated in such making construction,
This thing is your sum and substance of the submission is you are placing reliance on an inquiry report to say that in pursuance of an interim order and a detailed inquiry was conducted in which it was found that there is no material to show that this in the revised map, the area on which you have raised the construction of a commercial complex was earmarked for the purposes of park, even though in initial plan it may have been.
Absolutely. Absolutely, that's my precision.
Then what it's?
In case if 1987 has come into operation, that the structures made by the writ petitioner and all the occupants in the layout are in accordance to 1987 only. Presuming that if this 1987 layout is tampered or manipulated or forged, etc., the other structures in the entire layout, which is almost 159 structures, 159 houses, wouldn't have come into existence.
Yes.
The structures which were raised by these respondents, only after the conversion of land use, that is being done by the very authorities, that is society, respondents 7 and 8 who are steering the society, and they are the answerable persons in getting all these approvals and conversions. To the extent of conversions or approvals sanctioned by the authorities, they may not be in dispute as long as this approved layout is valid, 1987 layout is valid. Now, the other aspect is when the petitioner is intending to have this fact finding, whether such tampering was there, forgery was there, manipulation is there, this fact finding should have gone for a trial court, but under 226 or 227 or any of the provisions in the Constitution, this fact finding may not be that.
No, whether this issue of tampering with the record was there before the inquiry officer.
Yes, he made the all
First additional chief judge.
Yes, everybody presented and they
what is the finding recorded about tampering? There is no tampering.
Millard, may take to paragraph number 37 onwards, Millard. It is a continuous pages. It is a detailed studies being made, which comes at page 186, Millard. Starts at page 186. Paragraph 37 at page 186, Pallet. There are two paragraph number 37, so they sport at page 186. As this is for the reason at paragraph number 34, point for consideration was started by the inquiry officer, and at paragraph number 36, it is said at page 186, consequently, the point for determination is as to whether there was a revision of the layout on 10/4/1987, and if so, whether the dispute was converted for use of commercial shops. Now, this is being answered as already noted at paragraph 37. The second respondent, APHB, that is the Housing Board, has played a predominant role in the entire episode. Let me first have a glance at the stand taken by them in the statement. They clearly admitted that there is plan on tracing paper signed by their junior housing engineer, district housing engineer, and the regional housing engineer dated for 10/4/1987. As a matter of fact, after closure of the inquiry and when the matter has been practically resolved for submitting the report to the Honorable High Court, the Learned Counsel for the second respondent, APHB, filed the tracing paper containing the plan pertaining to revised layout dated 10/4/1987. Earlier, he had filed Exhibit B1, the Xerox copy of this plan on the tracing paper. This court understands that the Learned Counsel for the APHB filed this original plan on the tracing paper to meet the argument of the Learned Counsel for the sixth respondent that this court should draw an adverse inference against the APHB for not producing the original plan lying with the APHB. In fact, the Learned Counsel for the sixth respondent cited quite a number of decisions invoking the provisions of Section 114 of the Indian Evidence Act to draw an adverse inference against the APHP for suppressing the original plan, so that the tracing paper plan has not been given a separate marking, considering the fact that it is an important piece of evidence to decide the issue in controversy. I feel it just to admit the same and discuss about it. However, for convenience sake and for identification purpose, this particular plan is given marking as Exhibit B47. 37. I would like to continue to note stand taken up by APHB in their statement. It is pleaded that it is in the revised plan, the site in dispute has been shown as S1 and S2 shops. The copies of the revised layout were also furnished to various authorities by their officials, believing it to be the revised layout. However, it is further added that on a close scrutiny of the plan, it came to light that the said plan was tampered with, and words S1 and S2 shops have been subsequently interpolated. It is further stated that in the reference also there was interpolation with regard to the words shops to numbers. Finally, it is pleaded that by mistake and bona fidely the copies of the said plan were furnished to the authorities on 31/3/1999. The rest of the pleadings are extraneous and irrelevant for the purpose of the present inquiry report. Paragraph number 42, which comes at page 192. May I read the continuation of 38 also, Millet?
Yes, yes.
Yes, Millet. Let me now examine the evidence of RW1, which is the AP Housing Board officer, Millet, executive engineer working in APHP, who gave evidence basing on the record. Even in the chief examination, he admitted that he said the certified exhibit B1 to be true copy on 5/3/99 or 6/3/99. He further stated that when the MCH addressed a letter to their vice chairman to furnish a copy of the approved layout of the year 1987 exhibit B47, his vice chairman discussed the matter with the chief engineer, who in turn issued a memo to him to supply the copy of the layout, the chief city planner of the MCH. This witness further continued his chief examination by stating that after searching for the said plan quite for some time, he could trace out exhibit B47 plan, and after taking the blueprints of the same, supplied a copy of the same to the seventh respondent, Raghurama Reddy, and the representative of the MCH. According to him, exhibit B1 is a Xerox copy of the copy supplied to these persons.
So, Mr. One thing, your stand appears to be, I mean, subject to what you say. As we gather, your stand appears to be that there may be an interpolation, but this original 1 minute, there may be an interpolation, but it is for them to explain because it was the layout in their possession, not yours. And secondly, you say that in the revised layout plan, it was not earmarked as park. It was earmarked as a commercial space, and therefore you have utilized it, right?
Absolutely.
Huh?
Yes, Millet.
Is this the submission?
Yes, Millet. And as long as this the writ petitioner housing board demonstrate that there was interpolation and the people who indulged in such interpolation has been prosecuted in appropriate forum and they were convicted, as long as that things have not been ascertained, now we cannot presume at this stage that the layouts are interpolated or manufactured. Even if
No, Mr. C, there may be an interpolation, may not be an interpolation, but you say that you seem to suggest that it may not be relevant at this point of time because as per revised layout issued on 10/4/87, the area in this thing has already been earmarked for commercial purposes, correct?
Yes, Millet. Yes, Millet. May I take for a moment, my lord, to paragraph number 42, page 191 also, Millet.
This is what it is, sum and substance of the report. Why to read it? Yes.
Yes, yes, Millet.
What is your next submission?
Yes, therefore, Millet, as long as this 1987 is not denied and proved to be incorrect or improper or manipulated, Millet, the sale deeds which were acquired by this respondent numbers 5 and 6 of 1996, which almost a decade later, and the sale deed which I obtained would be specifying the schedule with, that is S1, S2, which is not the park. pursuant to the layout of 1987.
So this stand is substantiated by the inquiry report, right?
Yes, Mel. Yes, Mel.
What else?
Therefore, Mel, the petitioner cannot say that I made construction over the public park. In the absence of there being no public park, and in the absence of any such proof demonstrated to the clarity of everything that this layout is fabricated or manufactured, whatever it is, it cannot be said. But these are all taken the process of gazette notification with the state government as required under law. Having gone through the entire process of conversion of land usage, gazette notifications by the state government, will at this belated stage, can we go and say that 1987 is forced? Therefore, for two reasons, the petitioner is basically stopped from making such allegations, having obliged the 1987 layout for other house properties within that layout. Second is, as long as it is not being proved, the third point would be in the mind of petitioner, my lord, whether this 1987 layout is
how this report has been dealt with by previous decision of this court in division bench.
Let the judgment rent.
Get the judgment. No, yesterday we told you.
Yes, it is being submitted in the compilation also as a reported judgment.
So how it has been dealt with, Mr.
Well, there it was said that it was referenced to the master plan. Master plan.
260 is the order.
Yes, my lord. I'm sorry, my lord. That
page
223, my lords.
223.
223. This reported judgment punishment.
Yes. How this report has been dealt with, you please tell us.
Later. The questions which were tried by the previous in the previous proceeding would be at page number 228, my lord.
235.
228, 228.
No. The Mr. Prabhakar tells us para 34, 235. Is it correct?
We'll go for that, my lord. We'll go for that, my lord. Obviously, we'll take this other part of the appreciation.
He says para 26.
20 are the findings. I am going to the findings, my lord.
Yes.
But then what were the questions tried by in the previous process would start from page to 28.
That's all right. We have earlier date of hearing, we have seen this judgment. What we want to know is that how the report on which you have placed reliance has been dealt with by division bench, because 29.
The much impression.
Para
32 onwards, the appreciation has gone whether it is within the master plan confined or may take my notes paragraph number 32 of this previous judgment, Melon. It is therefore evident that inquiry officer misdirected himself in submitting the report on the basis that the land was not retained as park. Factually, that may be correct. But the question which arises for consideration is not as to whether an open space was not retained as park, but the question which ought to have been posed and answered was as to whether an open space which on his own finding was shown as park could have been converted for any other purposes whatsoever without following a procedure of law. The inquiry officer evidently has failed to pose to himself the right question for the purpose of determining the correct state of affairs so as to enable him to arrive at right conclusion and took into consideration irrelevant facts which were not germane for deciding the issue, and as such evidently misdirected himself in law. His findings as noticed herein before are also self-contradictory. Having regard to the fact that the various litigations are pending, the sole question which would arise for consideration is as to whether in terms of the provisions of the 1956 Act can the board revise the layout approved by Huda. Now, this is the question, the third question which I wanted to demonstrate is, writ petition was relying that the revised layout of 1984 was drafted by Housing Board, not by Huda, who is competent authority. In the absence of confirmation or approval by Huda, if layout is being prepared on the own of APHP, can we appreciate? Is it appreciated under the Act that APHP can go for revival of the layout? Well, that was the point which was discussed on the earlier occasion. But then, that is with regard to the competence. The writ petitioner was saying that this is being tampered or interpolated. That those facts would be asserted only by virtue of an inquiry or by virtue of a trial. Now, the competence of the APHP is concerned, my lord. There I am saying the petitioner would be stopped as because he had followed the same layout. I am going totally different footing, my lord, where can he be still allowed to agitate on a point which himself is abiding, which himself is accepting and proceeding. It is not the case of the writ petitioner that his approvals or his plot or his assigned house is not in accordance to 1987 second revised layout. And all the structures which are in existence are also in the revised layout. Well, if such is the case, then the entire property in 159 plots should be revived to this approved layout only. Why only this respondent? Had it been with regard to all the 159, then it's because of public interest. Here, the petitioner has some personal grudge against this respondent, therefore is invoking all this. That could be acted upon, subject to it applies to the entire layout or entire occupants, including the writ petition. Earlier, the competence of Housing Board was decided in this, whether the Housing Board is competent enough to revive the layout per se to 1956. That was the only adjudication made.
All right.
And
yes.
Therefore, my humble submission, the petitioner is not a right person to make such agitation, having accepted the contents of revised layout. That would be first and the last submission, as because the bill may not be tenable for the qualifications which are asserted by the writ petition, the affidavit, or the other material relied upon.
That's it. Anything else?
That would be sufficient. Anything commanded to clarify, I am available.
All right. Yes, Mr.
But,
you are the real culprit according to getting the petitions filed and.
No, I think.
Yes.
But the petitioner is an honest litigant. Yes, and genuinely
pursuing
this litigation. Not my friend, pointing out, that 1987 is a genuine layout. But he was giving, the relevancy to the particular date. Now, in the light of the counter filed by APHP, saying that it has been tampered and interpolated, giving a date, to an interpolated map layout, may not be correct. But there cannot be any relevance to a date for a interpolated or a tampered map layout. So that also is anti-date. And the other aspect, which my friend has pointed out, is that the layout, which was the sale deeds which were executed in favor of all the members of the society, are as per the revised layout. That may not be correct. If your lordship were to see the additional papers, which I have filed, at page number 45 and 46, I will only point out the difference between the two maps, two layouts.
Additional papers. Yes.
Because APHB's counter, additional counter in Supreme Court.
Yes.
Para 9, page 45.
Yes.
It total plots, are one type of plot. A plot, is there are about 50 per 9. Then, B plot, about 109. Total, there are 159 plots. Both A and B put together. Para 9,
Yes, yes.
Then, the tampered layout, is pointed out at page 46. The number of plots remain the same, 159. And the only addition is shops 2 numbers. So this only this part was altered. Their plots remain the same, and only part which was earmarked for only plot which was earmarked for part was converted for shops. So to say that all the sale deeds were as per the revised layout is not correct. All the sale deeds were as per the original layout. And only tampering is here, 2 shops. And other aspect is that which the inquiry officer did not go through, did not consider is the fact that whether the land, because the earlier division bench judgment reasoning would cover that particular aspect. I need not add anything more to it because it's already addressed on that particular issue.
Except case laws, right? You conceded yesterday that this you need to update the.
True, that I pass on.
Please pass on.
I will. Yes. That's the only thing. Because once even the inquiry officer starts with a note at para 34 of the inquiry report saying that the land was originally earmarked as
supposing, so Mr. Still, supposing if the shops have been like shopping mall has been constructed in violation of what relief? There are judgments of Supreme Court like Noida, Twin Towers, and Kerala flats.
They are consistently, the only thing, is that
you are not even citing those judgments.
Because I pass. Because your lordship would insist on the paragraph. I was just pointing out the paragraphs.
Oh, of course. I mean, you need to tell us paragraph, otherwise.
I'll pass on. I've got the case law.
But you mentioned paragraphs number, right? All latest case laws there.
I mentioned all the paragraph numbers.
Of this thing, Noida.
Yes,
apart from
I'll pass on.
Twin Towers, there is one more judgment.
I'll note down. I'll mention the paragraph numbers and pass on. But by 2:30, I'll pass on.
Yes.
That's all.
Anything else? Yes, Mr. Prabhakar.
And the MCH counter, in the Supreme Court.
No, Mr. You did not. What did he argue? He said that even if the records were in custody of authorities, not in the custody of 7 and 8, if there was tampering, it is for them to explain how it has been done. Even assuming there is a tampering, that it loses significance because subsequently this layout has been revised, and in revised layout, the land is earmarked for commercial purposes. So he says that even if tempering, not tempering,
it's
irrelevant.
That my senior friend would address. And on the aspect, once the APHP doesn't have power. That issue my friend did not address. The APHP does not have power to revise. Notwithstanding the fact, that APHP is unable to explain with regard to tampering. The APHP doesn't have power to revise the layout.
All right.
Therefore,
what about you have chosen him only and left everybody else? Revised layout, and he said that you have a plot in that revised layout, therefore you are stopped from questioning.
I have a plot, if there are encroachments in other areas, it's always open, to the...
Why have you chosen him only? And
there is no personal vendetta, to this individual, against this particular individual. It's only a earmarked as part, and we may be aware, he may not be aware with regard to this entire layout. There is an encroachment. The concerned authorities are always at liberty to initiate action.
That's it. You give that.
I'll pass on.
This compilation with paragraphs number. Yes, Mr. Prabhakar.
Here division bench said that permission from Huda was condition precedent. First layout was sanctioned by the Huda. Any deviation or alterations can be made only after the sanction is made.
Alteration can be made only by Huda.
By Huda, not because the original permission is also granted by Huda.
Yes.
Now,
under the act that stood at that time.
Power.
Under
Power.
the Urban Areas Act, AP Urban Areas Development Act. Section 14, Section 13.
Which year, Mr. This Act?
This is 1975, AP Urban Areas Development Act 1975.
Section
13 and 14 would be relevant. Application for permission is 14. So such an application was made at that time. So if there is any deviation or alteration, it has to go only from them.
So you're referring to section 14, right?
Section 13 is what it requires every development authority to approach them as soon as maybe after the commencement of this act, where government considers necessary to do so for the purpose of proper development of an urban area or a group of urban areas, may notification declare such a development area. Then, fourth, after commencement of this act, no development area shall be undertaken or carried out by any person or body, including any department of the government, unless permission for such development has been obtained in writing from the authority in accordance with the provisions of this act.
So who has altered the development plan in this case?
Later,
who has revised it subsequently? 10/4/87.
Because according to the housing board, it has not revised it. According to the respondent number 7 and 8, who are the vendors to 4 and 5, it is the housing board officials which gave them this plan, revised plan.
So Huda definitely has not revised.
That's why I wanted to invite your lordship attention. How to find by the Huda? They don't say that they have sanctioned it. On the contrary, they say all these pockets have been misused. Page 247 of this paper booklet which my friend passed on. This booklet, if your lordship looks into. It's not only this part, to that extent my friend is right. Page 247, lordship see.
Yes.
Paragraph 3, my lord. It is submitted that Hyderabad Urban Development Authority granted layout permission for Indian Airlines employees housing society situated in so and so. While granting, the layout authority has shown the open spaces in 6 blocks. Subsequently, on the report made by some of the employees that there are certain encroachments into the land, officers of the authority inspected the site and found certain encroachments in open land. The authority immediately addressed a letter in July 1997 to the Municipal Corporation of Hyderabad mentioned about the encroachments, called for to furnish remarks on said encroachments in the layout to take further action. According to the inspection report, the following are the encroachments made to the open lands. So item number 1 relates to the petitioner. According to the other 2 to 6 are also violations. But one thing to say that the other violators have not been penalized, please penalize them. It is another thing to say that since other violators are not penalized, don't penalize me. But that's not the law, at least.
Yes.
So, my friend, of course, obviously, naturally he will have a grievance because others are let off and I am not paid. This is because it's an eyesore entrance. It's a commercial complex, cellar plus 3 floors. In fact, they have made enough money for the last 25 years. The real point on which the matter is remanded to this court is not addressed by my friend. The point that was raised was in the adjoining layout. Originally, this is under the zoning regulations. This was a residential zone. The adjoining owner of some other premises obtained exemption from Huda for commercial purposes. So it was pointed.
What is the one more this thing? What is the consequence provided by statute in case of violation? Any other this compounding etc.
It is not there. This comes because so far as public areas and parks are concerned, even in case of BDA, as your lordship knows, where it was given for some other public purpose, like a school, the court said no, you can't do it. Parks, so far as parks are concerned, you can't change the. Maybe if it is a sort of a community center.
No provision in this act, right?
No provision in the act. And there can't be such a law that will be opposed again to 21 and 19. So that is it. In fact, the main basis on which the matter was remanded was that in an adjoining land, adjoining property about a few shops away from this. The zoning regulation was relaxed and commercial activity was permitted because originally this is a residential zone. But that is not the case of either of the party at this stage. My friend also has not raised it.
We don't know.
No, these are the, no, that is the additional documents.
In the order of demand, I mean, it doesn't, what you are saying is doesn't find place because you have appeared, that's why you know.
That's why your lordship says the order of the Supreme Court is that certain additional documents are filed in the Supreme Court.
Yeah.
So the Honorable Court said that can be taken back to this court. Anyway, my friend has not addressed it, therefore we need not have to labor on it. Those are the documents which form part of the additional documents filed before the Supreme Court. And one of the reasons for remand was that to look into those documents.
Stipler.
Supertech is the only judgment that is enough.
Supertech.
Supertech would be enough.
Yes.
I asked my friend to pass it on.
You are giving it's in your bunch?
Yes. I don't think it is there.
March
It's 100 pages, that's why.
Constantly about 100 pages.
That's why I have not.
No, whatever, I mean, you give.
That's enough. Supertech.
That will show the seriousness of this issue involved in the district.
Supertech will take care of all the matters. I'll pass it.
That's it.
I'll give a Xerox of it.
All right. Mark the
I'll say that it's delivered.
Arguments are reserved for delivery of judgment.
Subject leave, my lord.
You keep it native.
My lord, I'm the counsel for R7 in this case.
Earlier judgment division bench. It's there in that yellow, that compilation. Yes.
And one fact, my lord, additional counter filed in Supreme Court on behalf of MCH was by the commissioner. So the seriousness of the matter I just pointed.
Supreme Court.
On behalf of MCH, it was the commissioner who had filed there.
Actually, they got because to IAS officers.
Yes.
He made it a point.
Yes.
My lord, I'm the counsel for R7 in this case, Mr. Raghuram Reddy. He was the secretary of the Airline Housing Board. We'd like to submit that we'll be adopting the arguments of the counsel for R6 and R5.
Give that note is the pages. You are secretary of the society?
Yes, my lord.
R5 and R6, correct?
Yes, ma'am.
Wait, please. Counsel is on record, is out of country or she is in USA. Client had instructed, take no objection from.
Can appear, right?
She can't appear before. I want client has instructed to prepare no objection wakalat from her right to represent.
This is 2008 appeal, Mr.
Yes, your lord. Personal inconvenience, 4 weeks, your lord.
Hey, no, for.
She's in USA, she can't be
No.
wakalat for me. She's in USA, she can't be wakalat for me.
That doesn't mean that we will continue this thing.
I apologize.
With them. Mr.
She's
No
coming
apology.
in the month of October, your
You can very well appear on behalf of that grant.
You argue, what is there? Password tomorrow we will see.
I am not prepared and I don't have the file.
Tomorrow.
Your lordship. 1 week time.
Hey, what is this? Mr.?
I apologize. But
No, the apology doesn't help, right? What will we do with your apology? What will we tell us? The net result is you have tendered an apology. A 15-year-old case is adjourned. That is the net result.
1 week.
Now, what is this matter about? Let's see. 2000. No, I will stop. Then you should say this, right? Instead of give a copy of the petition to him also. Let's see, Mr. What is rejecting application for grant of and granting mining lease to fourth respondent. All right. So, madam, for what period you were granted mining lease?
But the lease period expires. It expansion more. Once the.
One minute. 1 minute. Who is not entitled?
It should not want that.
No, no, you are arguing both things, right? Period. Have you got no? Have you got the period? This period ended 15 days. But it was in 1980. Respondent number 4 was granted up to what time? 15 years. Yes. Page 2. Maximum W 771. Page 12. 770. No, petitioner was granted qualities. It was renewed. It was renewed up to 84. Where release on 15. And we can see the query list. Nothing. See, this is the level of assistance granted to the court, right? We have to look for everything for ourselves and hold that it has become infructuous, right?
Counted on record was lady or daughter has been appearing.
No adjournment, Mr. You, whatever you want to say, except adjournment, everything else, most welcome. Don't be, we are not handicapped, we are. Don't appear then, don't appear. Not on record, we may ask you how you are appearing, then what will you answer? You have done whatever you could, mister. You have done. She has not authorized you to keep on speaking till we agree. Did she tell you that keep on speaking till this thing? Is there any interim order? Interim order. She doesn't know.
What is the lease period? You're not saying that. See, 1610 out of status. The direction is fail to follow this mandatory requirement. Invite application 1.13 hectares. 12.5 of MC. Visit the direction. There is a status clear. Status clear. Therefore, she has no idea. She's telling us that I don't have the brief. See, we are too cautious in that because it's our order. They will file SLP.
ninth class, the same bona fide certificate they are not accepting for ninth.
Purchase committee was constituted and have become ineligible to become arbitrators and to continue as arbitrators. Section 12 has been amended by Amendment Act 2015 based on recommendation of the Law Commission, which specifically dealt with issues of neutrality of arbitrators. To achieve the main purpose for amending the provision, namely, to provide for neutrality of arbitrators, subsection 5 of 12, subsection 12, they found that notwithstanding any arbitrator, any prior agreement to the contrary, any person whose relationship with parties or counsel or subject matter dispute falls under any of the categories specified in the 7th schedule, he shall be ineligible to be appointed. The appointment would beyond pale of arbitration agreement, empowering the court to appoint such an arbitrator as may be permissible. That would be the effect of non-obstinate clause contained in subsection.
No, that is correct. That is to the effect of 12.5.
That's what.
No, but like, I mean, you are arguing that it will apply with retrospective effect. Where is that proposition?
In this case also, the arbitrator tribunal was appointed prior to the amendment, but they said they can't continue now, and a new arbitrator has to be appointed. That's what this. That's why, I was just trying to. Because in that case, the tribunal has already commenced its proceedings, but then there was a change.
Escape similar to the
1 minute. You let him complete. We are unable to get the submission like the proposition which he is relying upon.
Para 17. It cannot be disputed that in the present case,
I have a copy.
tribunal comprising of
I have a
officers.
copy. Copy of it.
Section 12, right with 7th schedule. Therefore, by operation of law and by amendment in section 12, beginning on statute subsection 5, section 12, right with 7th schedule, the earlier arbitral tribunal stationary purchase committee comprising of the additional secretary, Department of Revenue as president, deputy secretary, Department of Revenue, deputy secretary, General Administration, deputy secretary to government, printing, has lost its mandate. And as such, an arbitral tribunal cannot be permitted to continue. And therefore, a fresh arbitrator has to be appointed as per the Arbitration Act 1996. This is enough. In fact, there they were by office. Then 18, they said a similar question was there. In fact, the conclusion at page 20, para 20 and 21. 21 would make it further clear, in addition to what I have read. Even if I agree, they say May I read para 20 minutes? That would just make the convenience of the court. 20 and 21 would be enough. At page 19, not 19. In view of the above, and for the reasons stated herein above, the impugned judgment and order passed by the High Court is contrary to law laid down by this court in PRF and cited judgments. It is held that the Athlete Tribunal Stationary Purchase Committee comprising of, I'm omitting these designations, has lost its mandate by operation of law in view of section 12(5), read with 7 schedule, and a fresh arbitrator has to be appointed under the provisions of the Arbitration Act 1996. The impugned judgment and order passed by the High Court is therefore unsustainable and deserves to be quashed and set aside. In view of the above and for the reasons stated above, the present appeal succeeds. The impugned judgment passed by the High Court of Madhya Pradesh, passed in Allura paper means hereby quashed, set aside, an application being AC number filed by the appellant here before the High Court is hereby allowed. It is declared that earlier arbitrary tribunal so and so as members of the ineligible act continue as arbitrator in view of subsection 5, read with 7 schedule of the Arbitration Act, and therefore a fresh arbitrator is to be appointed to adjudicate upon and resolve the dispute between the parties.
Not agreeing. The issue has to be resolved at the stage. What he says, allow my petition and delegate to me. Then he also to be implemented. So instead of giving him so different. Otherwise, the entire plane was it not claimed. So if there is a concrete claim, it's going to ask. No, this, Mr. Prabhakar, as we understand, Supreme Court has not held in nowhere in this judgment that 12(5) amendment is retrospective in operation. On the facts of the case, they have appointed an arbitrator in accordance with the amended provision. This is what the ratio is. Nowhere it has been that whether it operates retrospectively, prospectively. Where, which paragraph? Nothing.
I think paragraph 20 itself says they have lost their mandate. The Adelaide Tribunal.
This is saying some.
By operation.
One sentence is not considering whether what intention of legislature has to be gathered when it is says there is no detailed discussion, right? You are on the strength of this judgment, you are entitled to argue that the arbitrator has to be appointed if the occasion arises to be appointed as per amended provision.
That's true. That is one aspect. That's all I'm saying. I'm not saying retrospect or prospect. Because the arbitrator would have to be appointed today.
Yes.
In any event.
So then he has agreed for appointment of an arbitrator.
The next aspect is whether such an arbitrator.
Now you are arguing that the arbitrator cannot be appointed at all.
No, I am on the. That is my second contention. But I have raised 2 points.
In this case also they had filed appeal. This thing,
that is because the
termination of mandate under section. On this very judgment, you can file an objection before the arbitrator saying that your mandate has been terminated on account of amendment. This is how the case arises on which you are placing reliance.
Madhya Pradesh High Court, but otherwise I'll bring the mother judgment. That would make it very clear. Mother judgment arises out of the Madhya Pradesh High Court judgment. I can, Lordship can put it tomorrow.
No, not tomorrow. This is of Mr. sufficiently old case.
That's why. But so far as this judgment is concerned, my submission is today they can't appoint a member of their service. It has to be an outsider. That my friend has agreed. But the other aspect I'm pointing out.
That's it. That's the end of it.
That is what.
That is the end of it. We will rely on this judgment and say that this appointment of an arbitral tribunal is set aside. That's why we asked you. You give an agreed name, we will appoint.
But another aspect is about the limitation. Because if it is 11(6), I can also raise before your lordships.
In a writ petition?
Yes. The contract. Where I am able to show the dates.
No.
Dates are clear. I am not asking any factual adjudication to be made. But it's not now as per the latest.
No, Mr. We don't know all this thing.
There are two things. But if I am
No, we don't know how. We would like to examine this matter in detail. Arbitrator is appointed state where writ petition is filed without taking recourse to the remedy provided under 15 and 16
That's true.
of the Code of the Arbitration Conciliation Act. Please tell us why we should not relegate and why we should entertain all these questions in a writ petition.
But it is like this. Not if I were to file an application under 11.6 today.
There is this thing also is a judgment of Supreme Court. This is against appointment of an arbitrator, right? Just.
But I'll satisfy your question. No, on both grounds. On both grounds. I put it on the ground of limitations. If your lordship looks into the other judgment that I have passed on. Because earlier the view was, today your lordships are appointing an arbitrator. Now your lordships are exercising powers under 11.6. Not instead of asking them to make a formal application, either of the parties. In a writ petition, this honorable court can exercise powers. But I am not saying no. This itself can be treated as an application under 11.6.
Not see, it is pending since 2004.
No, that's not. Let us treat it as an application of 2004.
It is in the interest of your client also.
If I treat it as a 2004 application, and if I am able to demonstrate before lordships that even in 2004 it's not. But that's what the Supreme Court said. This court will not appoint an arbitrator. The lordship may have a look at this judgment for a moment. 2021 5 SCC 705. Paragraph 12. But I just paragraph 12 is the arguments raised by the council. Because they were saying that explicit barred. Paragraph 12 may I read, but just to give the factual background so that at page 714, it's not the conclusion. Sri P.S. Narasimha, learned advocate appearing on behalf of the appellant, submitted at the date on which the request made for the appointment of arbitrator was received by the president of Secretariat Cantonment Board on 23/1/2007. As a result of this is the date on which the limitation period starts under Article 137 of the Limitation Act. Insofar as the application under Section 11.6 of the Act is concerned, for this purpose he relied upon the judgment of the High Court of Bombay and so, as well as recent judgment of this court, Geo Miller and Vidyut Nigam. He then argued that even so far as the cause of action on merits is concerned, it arose way back on 8/9/2003 when the respondent raised the claim with regard to the dispute for the first time. Once time begins to run, limitation cannot be extended by writing any number of subsequent letters. He also relied upon recent judgment of this court, Vidya Drolia versus so and so, stating that this case falls under para 148 of the judgment, and that claim was explicitly time barred and dead, and there was no subsisting dispute. Then there are paragraph 14, they refer to some other judgments. Then we can go to paragraph 18. Paragraphs at page 720. Then paragraph 19 is the conclusion. But 17, 18, I will not trouble the author by reading it, but it's a matter. That paragraph 19 is the conclusion. May I read 19? Applying para 19.
So when was the demand made for arbitration? Arbitrator, when was he appointed?
But the arbitration demand was made on 21/10/94. The appointment is on 24/6/2004. Roughly after about 9.5 years.
I don't know, the parties now in respect of government under 1 and 2. 112 the 30 years is a limitation.
That is for recovery of immovable properties. Government.
The parties may be private parties, I don't know. The judgment which is party. The parties in respect of private parties approval.
No, this is
137. In respect of kindly see the Limitation Act, Article 112.
Article 112.
Article 112, any suit except a suit before Supreme Court in the exercise of or original jurisdiction on behalf of the central government or state government, including the state government, that is Jammu and Kashmir, 2 years is the period of limitation.
So you are entitled to seek this thing appointment, right?
Yes.
That question we will kept open to be agitated in a proceeding. You invoke 11.6. We will keep the question of limitation open. We can argue. Why we decide here?
No, Virat, I think there's a small clarification that needs to be. It's what my friend is reading is with relevant.
No, whatever it is, he wants to contend, Mr. This when see the scope of this writ petition is confined to examining the validity of this order appointing arbitrator. That we are setting aside.
We have raised the limitation also. I have raised the issue of limitation.
That we are not examining. If as and when we are granting him liberty to file under 11.6,
very well.
In that proceeding you can raise the issue of limitation if so advised.
Achha.
And our order is subject to SLP.
No.
Yes.
We don't want. I always say that.
No.
Whatever court we are arguing, we should try to get an order from there.
No. Mr. You have a right.
That right would be our first fact.
Yes, fine.
And we don't want.
Mars. Please ask Mr. anything. Don't leave blanks. If you have any difficulty, ask me 10 times. I will patiently tell you. But don't leave the blanks.